Good evening, everyone, ladies and gentlemen. It's a pleasure. I was listening to Bonita. I was thinking to myself, I wish I can be so eloquent and entertaining as she is. I'm afraid I'm not, but at least I will be no less exciting, I think, with my things. First of all, let me thank you, especially the organizers, Manuela and the faculty and the university. I truly feel honored to be here as part of this magnificent set of foreign experts. There are very few times in the year we get together, so I'm going to benefit a lot of the company as well. But I also feel privileged to be with you and to have the opportunity to learn and listen to you as well. And this is something that we missed a lot, especially when we work in global issues, and the feel on the touch of reality, pragmatism, and what's happening on the ground. So Surya and Sheldon have said that the area, the field of business and human rights is rapidly evolving. And it is true, it's indeed evolving very fast. In only one decade, we have seen the adoption of the guiding principles, a landmark achievement. And now, just recently, last year, the adoption of a resolution, the resolution 26/9. What's the resolution 26/9? The Human Rights Council established an intergovernmental working group, an intergovernmental process to start elaborating a treaty, a legally binding instrument in the field of business and human rights. That's an outstanding achievement, something very important. When I think about this, I say to myself, I study law, I'm doing my master's, I'm doing my PhD, and I practice law at the global level. And as a jurist, I feel excited because I think we are at the beginning of a new branch of international law. Truly, this is something very similar to the moment in which we started to talk about the ICC statute, the International Criminal Court, and we were to create an international jurisdiction to deal with crimes committed by individuals. But now we are targeting these actors, private actors in particular, the business enterprise. And this is something that hasn't happened before. For one thing, the resolution of this step taken by the Human Rights Council is remarkable in many respects. First, it's the first time a binding instrument is going to be discussed and elaborated in the field of business and human rights. Secondly, it's the first time that this is going to be done through an intergovernmental process. The guiding principles were developed by an individual expert, an independent expert. He did a wonderful job. We can, of course, assess that the guiding principles were more effective or not, but the fact that they were elaborated over a course of 6 years and they were adopted or endorsed unanimously by the international community is in itself remarkable. But only 3 years after the adoption of the guiding principles, the Human Rights Council decided to go one step ahead and decided to start a process to elaborate a treaty. And what is more important, perhaps, is that the resolution is a very strong resolution, establishes already a roadmap, says that over the 2 years we will have a broad discussion about the possible content, the format, even the nature, it says, of a legally binding instrument. And in the 3rd year, we will already start discussing about the elements, the shape of the treaty, which is already kind of gives us assurances as to what is going to happen in 3 years. It's a very strong resolution. But on the other side, there are some drawbacks, of course. First, the resolution wasn't unanimously adopted. The resolution was voted and passed by a very narrow majority. the countries that are home states to the big transnationals and to the most of the investors, European countries and North America, voted against, and a good number of other countries abstained, including Brazil and Argentina. And there is a footnote in the resolution that seemed to restrict the future scope of this treaty to only transnationals. And this is something that's going to be discussed, that has been criticized. But at the end of the day, what this kind of treaty is going to accomplish, what kind of content it's going to have, what objectives it's going to meet, all these questions are going to be answered in due course in the process of elaboration of the treaty. But we will also have a seminar tomorrow after 6, I think, with Professor Surya Deva, in which we will go a little bit in depth into these issues. So I invite you to come to that seminar. But for one thing, this kind of instrument, a legally binding instrument, accomplishes already 2 objectives. In the first place, as any other international treaty, it provides the strongest impetus for national legislation, for the passing of national legislation. If you see the practice of, in relation to other treaties in the area of human rights, you will see that whenever there is an international treaty, that provides a strong argument for national parliaments and for national advocates and groups, NGOs, etc., to mobilize political will at the national level. When there is an international obligation, there is a need for national implementation. And that national implementation usually takes the shape also of legislation, which is very important. And the second objective that's going to be accomplished is to create and build international institutions, international machinery. This is something that cannot be accomplished by other means, cannot be accomplished by directives, guiding principles, recommendations, etc. at the international level. Because none of them can create institutions, none of them can create committees, none of them can create international bodies. That has to be done through an international treaty, always. If we are going to create an international tribunal on corporations, as some people want, that has to happen through an international treaty. There is no other way. So this is the inception, this is the beginning of hopefully a new branch of international law that will take us to the development of these institutions as well. In terms of content, of course, we weren't going to discuss, we will have plenty of time to throw out ideas on what the content of this treaty should be. Many people believe that the emphasis should be on the legal responsibilities of business corporations, especially the sanctions, the kind of definition of offenses. Some people talk about crimes committed by corporations. Others believe that, or the same people also believe that there should be provision for international cooperation for the investigation, prosecution, and sanction of these offenses across jurisdictions. Many people believe also that we should focus perhaps on an international tribunal or international criminal tribunal for corporations. There's also some people here, even in the room, that think that should be doable. Others will put more emphasis on the rules that define in the extraterritorial jurisdiction of national courts and other regulatory institutions. Now, in which cases national ministries or the courts of a given state will have jurisdiction over the wrongful conduct of an enterprise committed abroad in another country. That's a sort of extraterritorial jurisdiction. But all that will be discussed, and there's plenty of space for all of us to suggest what we think it's doable at this level. Let me finish. I think I promised to be brief, but I hope all this is exciting for you. a judge, an Austrian judge, in a seminar we had in Geneva last year, when we were talking about voluntary approaches as compared to legally binding approaches, she said, I used a very beautiful phrase that I always use, either at the beginning or at the end of my presentations. She said, guidance, and she's an international judge, by the way, she served an international criminal tribunal for the Sierra Leone, for instance. She said, guidance is for the willing, the law is for the unwilling. Yeah? And I think it's very clear, that phrase, I don't need to explain it. The need for law, whether at the national level or at the international level, is very clear. One of the limitations, not necessarily the failure of the guiding principles, is a limitation for its very nature. It's not binding, so it cannot provide for accountability necessarily. And international treaties, at the end of the day, are just instruments. They're just tools. They are not necessarily, we are not going to confuse or put all our eggs and just fight for having an international treaty, regardless of what is the ultimate end. The ultimate end is, of course, to achieve full respect for the rights of people and to provide the means for them to hold accountable to the perpetrators or violators. So that's the ultimate end. And the treaty is going to be just one instrument in the hands of the people, advocates, lawyers, jurists in general, social activists that will want to do that. So with this, of course, thank you again for the invitation. I hope all this is very useful for you, and I look forward to the discussion during these days. Thank you.